Listen to me very carefully, because what just happened in Washington wasn't a ruling, wasn't a clarification, and wasn't another technical adjustment to gun policy. This was a judicial ambush that no one saw coming. The Supreme Court just unleashed a December decision so sharp, so direct, and so unforgiving that it didn't just affect the Second Amendment debate, it reset the entire legal battlefield in one strike. Overnight, the rules changed. Overnight, the boundaries shifted. Overnight, every state, every federal agency, and every gun owner in America was thrown into a new era where the old assumptions no longer apply. The court didn't wait for Congress. The court didn't soften the edges. The court didn't leave room for loopholes or creative interpretations. They dropped a decision that slammed the legal door shut on decades of regulatory drift and opened a brand new constitutional lane that millions of Americans are about to step into, whether Washington likes it or not. This is the ruling lawmakers feared, the DOJ dreaded, and every gun owner needs to understand right now before the full weight of this December shockwave ripples across the country. What unfolded inside the Supreme Court this December has already been called one of the most consequential firearms opinions of the modern era. Not because it struck down a single law or focused on one specific regulation, but because it established a sweeping new legal standard that instantly places pressure on every firearm rule in America, from the federal level all the way down to county ordinances. It is a ruling that legal scholars describe as the court planting a new constitutional flag, a line in the sand that lower courts must now follow, whether they agree with it or not, and the message behind this decision is unmistakable. The era of speculative modern justification gun control is over. The Supreme Court's December firearms ruling demands historical grounding, factual justification, and constitutional consistency, and it is already sending shockwaves through the DOJ, the ATF, state legislators, and gun control organizations that relied for decades on broad, flexible interpretations to uphold restrictive laws. The case reached the court under circumstances no one expected. Lower courts were split. Federal agencies were scrambling to defend contradictory standards, and several states had passed sweeping firearms restrictions in the months following earlier decisions like Bruin and Raheim, believing they could carve out new categories of regulations by framing them as public interest measures. But the Supreme Court saw the chaos building, saw the conflicting interpretations, and saw the growing tension between modern political agendas and the historical boundaries of the Second Amendment. Instead of allowing that tension to drag on for years, the court intervened with a clarity that shocked both sides of the gun debate. The December ruling effectively told the nation, the Second Amendment has rules. Those rules are rooted in history, and the government does not get to reinvent them on the fly. At the center of this ruling was a simple but powerful legal question. Can the government restrict firearm possession or ownership based on modern concerns if those concerns did not exist at the time the Second Amendment was ratified? The court's answer was emphatic and definitive. No. The justices wrote that constitutional rights cannot be reshaped around contemporary anxieties or shifting political priorities, because doing so would reduce the Constitution to a flexible policy document rather than a fixed guarantee of liberty. In other words, if the government wants to limit firearm rights, it must point to historical analogies that clearly existed during the founding era, not modern assumptions or generalizations about risk. This was the turning point of the entire decision, the line that cut through decades of lower court rulings that had upheld gun restrictions based on public safety arguments with no historical foundation. For years, courts relied on interest-balancing tests, weighing the government's desire to prevent harm against an individual's constitutional rights. The December ruling abolished that approach entirely. The court stated unequivocally that constitutional rights, including Second Amendment rights, cannot be balanced away in the name of public policy. They are either protected or they are not. They either have historical precedent for limitation or they don't. And if they don't, the government loses. This standard immediately places dozens of existing regulations at risk. The December ruling did not specifically strike down individual laws, but it set a constitutional formula that will be used to evaluate every firearm case moving forward. Laws dealing with magazine capacities, permit systems, waiting periods, training mandates, registry schemes, accessory restrictions, and even certain types of background checks now face a dramatically higher legal threshold, one that many states and federal agencies cannot meet. And what makes the situation explosive is that the Supreme Court knew this. The justices knew when they issued this decision that they were cracking the foundation beneath the most controversial gun laws in America, and they did it anyway because they determined that the Constitution left them no other choice. Inside the DOJ, the reaction has been described as frantic. Attorney groups who relied on flexible interpretations to defend restrictions suddenly found themselves stripped of their strongest arguments. The department can no longer tell courts that a law is justified by modern crime trends, new threats, or updated public safety needs. The Supreme Court's December ruling forbids that approach completely. If the reasoning does not align with historical tradition, it is invalid. This means the DOJ must now defend laws it previously treated as secure, but without the tools it used for decades to justify them. Several internal memos leaked from federal agencies indicate real concern that the December decision could lead to a domino effect where entire classes of regulations fail in court one after another. The ATF is feeling this pressure even more directly. Federal regulatory authority over firearms has always relied on interpreting statutes broadly, expanding definitions, redefining components, and stretching the meaning of statutory terms to apply modern enforcement strategies. But the December ruling significantly weakens that flexibility by reinforcing the principle that agencies cannot expand their power beyond the historical scope of the Second Amendment. The court took aim at the pattern of policy redefinitions the ATF used in recent years, stating that constitutional rights cannot be subject to regulatory reinterpretation without explicit congressional authority. This means rules involving pistol braces, frames, and receivers, reclassification of accessories, and enforcement interpretations rooted in agency discretion could face legal collapse. The ruling also exposes state laws to immediate vulnerability. States like New York, California, New Jersey, and Illinois passed aggressive gun restrictions under the belief that the Supreme Court's earlier decisions left room for broad regulatory frameworks if they were framed as modern necessity. But the December ruling shuts that door entirely. The court stated that states cannot create new categories of firearm regulations that did not exist historically or that contradict the plain text of the Second Amendment. States may not impose licensing requirements that treat constitutional rights as government-issued privileges. States may not rely on modern fears or political disagreements to justify restrictions. And states may not sidestep the standard by inventing new terminology or reclassifying ordinary firearms or accessories under novel definitions. This is why state attorneys general are panicking. Their entire legal strategy is now outdated, and Brown states are responding immediately, issuing statements declaring that the December ruling confirms the unconstitutionality of many federal and state-level restrictions. Several governors have already announced plans to revise their firearm codes to align with the Supreme Court's standard, anticipating that lower courts will begin striking down non-compliant laws over the next year. Gun control groups reacted with shock and intense frustration. They argued that the ruling ties the government's hands and ignores modern realities. But the Supreme Court addressed this directly in the decision. The justices wrote that the Constitution is designed precisely to prevent government officials from reshaping fundamental rights based on shifting fears or temporary political pressure. They warned that allowing modern justification arguments would permit nearly limitless regulation, turning the Second Amendment into a conditional privilege controlled by lawmakers rather than a constitutional guarantee. On the other side, gun rights advocates are treating the December ruling as a major milestone, possibly the most important decision since Heller. They point out that the Supreme Court did more than clarify standards. It established a legal structure that leaves no room for interpretation beyond the historical record. For them, this ruling confirms that any law lacking historical grounding, which includes many of the most restrictive modern gun policies, is on borrowed time. Attorneys, advocacy organizations, and state legislatures aligned with the Second Amendment are preparing a wave of legal challenges, confident that the new standard gives them the strongest foundation they have had in decades. The deeper significance of this ruling is that it redefines the entire relationship between citizens, states, and federal agencies regarding firearm rights. For the first time, the court explicitly stated that the Second Amendment must be treated with the same constitutional rigor as the First Amendment and the Fourth Amendment. No more treating it as a second-class right, no more exceptions based on political preference, no more bending the rules to accommodate government regulatory strategies. The December ruling states plainly that the Second Amendment is a fundamental right rooted in individual liberty, not a flexible guideline to be shaped according to social trends. This decision also triggers a cascade of legal questions that courts will now be forced to confront. If permits, licensing systems, and registration schemes lack historical precedent, can they survive? If accessory restrictions cannot be tied to founding era analogies, can they remain enforceable? If states cannot impose discretionary standards for carrying firearms, what happens to states that still use them? And if the government cannot rely on modern public safety arguments, how do they defend laws designed around modern threats? Many legal experts believe that the December ruling is the beginning of a much larger judicial shift. The Supreme Court appears to be preparing for a series of future cases that could further define the outer boundaries of constitutional firearm regulation. Some analysts predict that the court is setting the groundwork to dismantle significant portions of the NFA and GCA frameworks by applying this historical standard more broadly. Others believe the court is signaling that it will no longer tolerate agency-driven reinterpretations of firearm classifications, and still others argue that the ruling prepares the path for potential challenges to interstate firearm transport rules, magazine bans, suppressor restrictions, and registered item requirements. What matters right now is that the December ruling is already reshaping the legal landscape for gun owners. The message is clear. The Supreme Court has placed constitutional protection above political preference. They have reestablished historical grounding as the only valid basis for firearm regulation. They have rejected speculative arguments and modern justifications, and they have given courts across the nation a strict, inflexible standard to follow. But the most important part of this decision is its long-term impact. This ruling is not just for December. It is not just for one case. It is the framework that will guide the next decade of Second Amendment litigation. It sets the stage for broader challenges, deeper constitutional review, and an eventual reckoning for laws that have survived only because courts allowed modern arguments to override historical limitations. As legal challenges begin to stack up, as states adjust their statutes, as federal agencies scramble to adapt, and as gun owners try to understand what this means for them, one thing is certain. The December Supreme Court firearms decision has launched the next era of Second Amendment law in America. The old rules are gone. The new ones are here, and every gun owner must understand what comes next, because the legal fight that has just begun will determine the future of the Second Amendment for an entire generation.